Yes, good evening to the participants of the JCJ 2023, which is going to be held on 7 January 2023. Anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
It is an Act Specific Relief Act 1963.
That much only.
Welcome to the aspirants of 2023 virtual class. The Act contains 3 parts and 8 chapters. Part 1, preliminary, contains 4 sections. Important section is section 2, in which there are definitions of different terms used in Act. It also states that the term which is not defined in this Act has same definitions as defined in Indian Contract Act. Virtual class on 26-12-2022 from 9 pm to 9:50 pm. Section 4 states that specific relief is only granted for enforcing civil rights and not penal rights. Professor Dr. Mohammed Saheb Hussain.
Good. And in my yesterday class, I did up to the 33 question, which is on Saturday, and today is Monday because Sunday is holiday. 24th question, be ready to shoot. It was held by the Honorable Supreme Court that when the plaintiff files a suit regarding the disposition, it is enough if he proves that he is entitled over the title of the property. Once the title is proved, other details like being divested from the property or other things are not required to be proved was decided in the case of Dash. A. Tarachand versus Bhanwar Lal. B. Sri Manoranjan Chowdhury and others versus Sri Paritosh Das. C option, Geeta Rani Pal versus Debayandu Kundu. D. Navakumar Sarkar and others versus Srimati Rajdevi and others.
Option A, sir. Option A, sir.
WRONG.
Option B, sir.
WRONG.
Option D.
WRONG. If you say option D. The right answer is
Option C.
Geeta Rani. Option C, Geeta Rani Pal versus Devayendu Kundu. In this case, it is decided. 35th question. Which statement is right under the Specific Relief Act? 1, 2, 3 I have given. 1. Proviso Order 39 Rule 3 expresses unequivocally that in such situations, the reason must be noted apart from the 3 pillars that serve as the foundations for injunctions. 2. Section 95 of the Civil Procedure Code also states that if a temporary injunction is granted, 3. Perpetual or mandatory injunction are not covered under the CPC. Option A, 1 plus 2. Option B, 1 plus 3. Option C, 2 plus 3. Option D, 3.
Option B, 1 plus 3, sir.
WRONG.
Option D. 2 plus Option 3. D. Option D.
The option D is the correct one. And it says which statement is right under the SRA, means Specific Relief Act. Number 1 is wrong, number 2 is wrong, number 3 is right. Reason is perpetual or mandatory injunctions are not covered under the CPC, but rather in Specific Relief Act 1860. To write 39 in the Roman numbers, we will first express 39 in expanded form. 39, how do you write it? 10 plus 10 plus 10 plus 10 minus 1. That means x minus 1. So Roman number is 39. Whenever you write the order should be Roman capital. But instead of saying Roman capital, we can also say uppercase letters Roman. That is also the way of saying. Shall I proceed? Say
Yes,
yes.
sir.
36th question. The schedule in the Specific Relief Act 1963, there is one schedule is there. In that schedule, if you happen to see the category of the projects and infrastructure subsection, it refers to the two sections of the Specific Relief Act. A, sections 20 and 41 HA means clause HA. Option B, section 20 capital A and 41H. Option C, section 20 capital A and 41 clause small a. D, sections 20 capital A 41 within parentheses clause HA small HA. Out of the A, B, C, D, which is the right option in the blank?
Option D, 20 class A and 41 class HA.
Option D is the right answer. It is section 20 capital A and 41 clause H small a, HA. That is the right answer. It belongs to that, the schedule belongs to that, these two particular sections of the Specific Relief Act. 37th question. What is the sequence, correct sequence or the exact sequence in the schedule? Because here given the A, B, C, D. These are the sequence I maintain. Transport, energy, communication, social and commercial infrastructure, and later on, water and sanitation. That is A. Now, B, transport, energy, water and sanitation, communication, social and commercial infrastructure. C option, communication, transport, energy, water and sanitation, social and commercial infrastructure. D, transport, energy, water and sanitation, communication, social and commercial infrastructure. Out of A, B, C, D, which is the exact sequence?
Option D.
Option D is the exact sequence. Number 1, transport, later energy, later on water and sanitation, communication, and the last one is social and commercial infrastructure. If you happen to see the section, that is the sequence you could find it. See here the sequence I have given. Feedback. 1, transport. 2, energy. 3, water and sanitation. 4, communication. 5, social and commercial infrastructure. Now the 38th question. Mismatch the following section with its explanation or narration in part B. I said mismatch. Number 1, section 36, preventive relief, how granted. Number 2, section 39, mandatory injunction. Number 3, section 37, class 1, subsection 1, perpetual injunction. And the 4th, section 37, subsection 2, temporary injunction. And these are the tables, part A, part B. Now the options. A, 1 plus 2. B option, 1 plus 3 plus 4. C option, 1 plus 2 plus 3. D option, 3 plus 4.
Option D, 3 plus 4.
Option D, sir.
Option D is the right answer. Only 3 plus 4 is the right. Other two are mismatched. Is it clear?
Yes, sir.
Good, good. See the feedback. Section 36, preventive relief and how granted. And section 39, mandatory injunction. And section 37, 1, temporary injunction. 37, 2, perpetual injunction. I changed it there. Is it clear?
Yes, sir.
Yes, sir.
Good, good. Now let us see the next 39th question. Match the following part A and the explanation in part B. Part A, 1, part 1, 2, part 2, 3, part 3. Part B, A, specific relief, B, preventive relief, C, preliminary. Now the option. A option, 1A, 2C, 3B. B option, 1C, 2B, 3C. C option, 1B, 2A, 3A. D option, 1C, 2A, 3B.
Option D, 1C,
D, sir.
2A, 3B.
I appreciate. Now, my participants are know that angle and to see the elimination method. If one you eliminate it, automatically the second and third you will get the answer. So feedback I have given part 1 is the preliminary, part 2 is the special relief, part 3 is the preventive relief. These are the sequence. Now 40th question. Match part A with the chapter explanation in the part B. Part A and part B. 1. Chapter 3. 2. Chapter 4. 3. Chapter 5. 4. Chapter 4. 6 in Roman capital. Roman upper class number. Okay, here A, cancellation of instrument. B, declaratory decrees. C, rectification of instruments. D, rescission of contract. Option goes in this manner. A, 1C, 2D, 3B, 4A. B, 1C, 2D, 3A, 4B. C, 1B, 2C, 3A, 4D. D, 1D, 2B, 3C, 4A.
Option B.
Option B, 1C,
Option B,
2D,
sir.
3A,
I appreciate. I have a hat trick. Today that you people made the hat trick. Yes, here the feedback is chapter 3, rectification of instrument. Chapter 4, rescission of contract. Chapter 5, cancellation of instrument. Chapter 6, declaratory decrees. Okay. Now 41st question. Anyone can unmute and read? Loud voice.
41 question. Dash of the Specific Relief Act 1963 lays down the provision of the declaratory decree. Option D, sir, answer. Option A,
You read
section
the
31.
options.
Option A, section 31. Option B, section 32. Option C, section 33. Option D, section 34.
You are right.
Option D.
Yes, it is option D is the right answer. Is it that option D is the right answer? No.
The effect of discretion of the court.
No,
Which
sir.
is the
Which
right answer?
provision of the declaratory decree? They asked.
Effect of declaration, section 35. Section 34 is the right answer. Declaratory decree.
Are you sure?
Yes, sir.
Okay, I appreciate. If it is true, because I don't want to go for the details. Okay, now let me check it because I got the doubt. Now I'll check it because it will not take that much time to check it. Yes, the declaratory decrees are here. Arrangement of second. Oh, it is here. So you said option 34, is it?
Sir.
Yes, I will check it now. Section 34 you said, no? Just I will type 34. Declaration of the court as a declaration of statute or right means 34 is the right answer. Okay, why we should have to go there with the doubt? Better you should make it clear. Agreed? Never sleep with the doubt. Okay, now next question, 42nd question. The contract was breached due to the conduct of the plaintiff, virgule purchaser, who were not willing to perform the contract after entering into a dash agreement. Read the option.
Option A, limitation bar. Option B, time bar. Option C, time sensitive. Option D, watch based.
Option B, time bar.
All are very near.
Time sensitive agreements.
It is a time sensitive agreement. That is the appropriate word. Of course, the other words are very clear, but the appropriate word is there, the C option, time sensitive. You know, sometimes your password is uppercase or lowercase sensitive, they will say. That means, what is uppercase?
Capitals.
Capital. In the typewriting, there is uppercase and lowercase is there. Lowercase means small letters. And they are capital sensitive, or we can say upper sensitive or lower sensitive or sensitive capital or sensitive letter. They will say in that way. Okay, now let us see the 43 question. The following case below discuss about the section 12 of the SR Act, means the Specific Relief Act. Which case law is correct one? Number 1. Srimati Katta Sujata Reddy and others versus Siddham Setti Infra Project Private Limited and others. 2. Siddham Setti Infra Project Private Limited versus Debbard Vishweshwara Rao, dead through the legal representative and others. 3. Debbard Srinathar Rao and others versus State of Telangana and others. Option here I mentioned is A 1 plus 2, B 2 plus 3, C 1 plus 3, D 1 plus 2 plus 3.
Option C, sir.
D, option C,
C,
1
sir.
plus 3.
If you say option C, WRONG. If you say option D, WRONG.
Sir, option B 2 plus 3.
Option B is the 2 plus 3 the right answer. Only 2 cases are there which says about the section 2 of the SR Act. I think whether the 2 section, because I quoted from the same section 12. Anyway, I will make it the clear this thing, because I know it is, I framed it, but I took it all the 3 from the same section 12. Okay, you take the snapshot, screenshot. I will clear you at the end of the class if the time left. Okay. Say yes.
Yes.
Good. Read the 44th question.
44th question. The Law of Specific Relief Act 1963 works on a basic principle that possession is itself dash evidence of the ownership. Bracket within brackets exact answer. Option A prima facie. Option B italic mode in prima facie. Option C basic. Option D main. Option B, sir.
Option B is the right answer. It is the prima facie of the ownership. But Professor Hussain students will not read bracket. They will say parenthesis, exact answer. Within parenthesis, exact answer. But I appreciate you read very beautifully option B, italic prima facie. I appreciate.
Thank you, sir. Thank you.
I appreciate the way that you read it. Yes, 45th question. I quote, settlement, I unquote, means an instrument within parentheses other than a will or codicil as defined by the Indian Succession Act 1925, Act number 39 of the 1925 within parentheses, whereby the destination or the devaluation of successive interest in movable or immobile property is disposed or is agreed to be disposed of. Option A, cap 2, clause A. Option B, 2, clause B, means section 2, clause B. Option C, section 2, clause C. Option D, section 2, clause D.
Option B to class B. Option B to class B.
You gave the answer in the chorus.
Option B to class B.
Yes, if you say option B, section 2, class B is the right answer for the settlement. That is the appropriate answer. Yes, 46th question. Contracts not specifically enforceable. The following contracts cannot be specifically enforced. Namely is the English equivalent. What is the Latin terminology? Supplementary question. If you don't know, you say pass on. I will give the answer.
No, sir. No, sir. Pass.
Capital V, I, small z. Vis means videlicet. That is the Latin terminology. Its equivalent is namely. But naturally, I will write here. Capital V, I, Z, full stop, and comma, continuation. And this should be the Latin terminology. Hence, it should be italics. That is the word. Vis means namely. The full form is videlicet. Okay, now you don't worry about that one spelling. Okay, now the first where a party to the contract has obtained the substituted performance of a contract in accordance with the provision of Section 20. 2. A contract, the performance of which involves the performance of a continuous duty which the court can supervise. 3. A contract which is so dependent on the personal qualification of the parties that the court cannot enforce the specific performance of its material terms. And 4th, a contract which in its nature determinable. Options: A, 1 plus 2 plus 3, B option, 1 plus 3 plus 4, C option, 1 plus 2 plus 4, D option, 1 plus 2 plus 3 plus 4.
Option B,
Option
1
A.
plus
Option
2
A,
plus 2. Option B, 1 plus 3 plus 4.
Option A 1 plus 2 plus 3.
Option A, sir.
If you say option A, it is WRONG.
Option B, sir.
D.
1 plus
If you
3.
say option B, RIGHT. If you say option C, WRONG. If you say option D, WRONG. So what is the right answer?
Option B, 1 plus 3 plus 4.
Yeah, because here I have given the reason.
Court cannot supervise.
A contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. Is it clear?
Yes, sir.
Yes, sir. Yes, sir. Yes, sir.
Okay. 47th question. Injunction, when refused, an injunction cannot be granted. Find out the odd man out. Means, which is false one. A, to restrain any person from prosecuting a judicial proceedings pending at the institution of the suit in which the injunction is sought, unless such a restraint is necessary to prevent a multiplicity of proceedings. B, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which an injunction is sought. C, to restrain any person from applying to any legislative body. D, to restrain any person from instituting or prosecuting any proceeding in a civil matter. Which one is odd one
Option
out?
D.
Option
Option D.
D.
Option D.
Oh, sir,
Are you
option
sure?
C.
Option C, sir.
Option
C.
Option D is the right answer. To restrain
matter.
any person from instituting or prosecuting any proceedings in a criminal matter. Is it? Or in civil matter? Criminal matter only. But I made the civil matter here. Is it clear?
Yes, sir.
Yes, sir.
48th question. Injunctions when refused. An injunction cannot be granted. Find out the correct statement. I say correct statement. 1. To prevent the breach of a contract, the performance of which would not be specifically enforced. 2. To prevent on the ground nuisance, an act which is not reasonably clear that will be a nuisance. 3. To prevent a continuing breach in which the plaintiff has acquiesced. 4. When equally efficacy relief can certainly be obtained by any other usual mode of proceeding except in the case of breach of trust. Here I have given the options. Option A, 1. Option B, 1 plus 2. Option C, 1 plus 2 plus 3. Option D, 1 plus 2 plus 3 plus 4.
Option D, 1 plus 2 plus 3 plus 4.
All are correct. Hence, option is option D, 1 plus 2 plus 3 plus 4 is the right answer for the 48th question. Now, 49th question. All other words and expressions used herein but not defined and defined in dash have the meaning assigned to them in that act. If you are having the thorough memory, you can give the answer A, B, C.
Option B. Option B. Indian Contract Act.
Why I have said if you have the IQ or a memory, you can easily give the answer I told. Why? In the beginning, I have shown you this thing. Is it or not?
Yes, sir.
And the part 1 preliminary contains the 4th section. It is clearly mentioned there. in this act has same definition as defined to Indian Contract Act. But you did not give me the answer. Sir, we have forgotten, sir. But we know the answer. But I gave the hint to you. I have shown you. That is the wording that I used. But anyway, it doesn't matter. But you give the right answer. You give the right answer. Okay. Fifth question. 50th question. Specific Relief Act 1963 grants A. Specific relief, B. Preventive relief, C. Both A and B, D. None of the above.
See both A and B.
B, both A and B.
It is a very easy question, but I want to test you whether you can make it out or not. There are the two types of the grants, specific relief or preventive relief. Now I will ask you, what is meant by preventive relief? Supplementary question.
Nothing but injunction, sir.
Nothing but injunctions. How many types of injunctions you know under the specific relief? Supplementary question.
Mandatory injunction.
Two categories.
Habitual injunction, mandatory injunction.
See, there are two types of injunctions are there, but the other type is there only in the CPC.
Temporary injunction.
Yeah, please note the point. There are certain injunctions is not covered by the Specific Relief Act. Only CPC will cover it. I believe it is a prohibited injunction, if I not be mistaken. But anyway, let us check it.
Yesterday we studied it.
Yeah, yesterday also we dealt it, that thing. Is it or not?
Sir.
Okay, 51 question. A plaintiff instituting a suit for the specific performance of a contract in writing may pray in the alternative that if the contract cannot be specifically enforced, which one is correct option? A. It may be declared as unenforceable. B. It may be rescinded and delivered up to the cancel and the court, if it rectifies to enforce the contracts specifically, must direct it to be the rescinded and delivered up accordingly. C. It may be declared as void. D. None of the above.
Option B.
Option B is the right answer. And this is, I know, I copied somewhere, but I changed certain wordings and made it. But the right answer is, it may be rescinded and delivered up to be cancelled, and the court, if it rectifies to enforce the contract, especially may direct it to be the rescinded and delivered up accordingly. If you happen to see the section 29, alternative prayer for the rescission in suit for the specific performance, a plaintiff instituting a suit for the specific performance of a contract in writing may pray in the alternative that if the contract cannot be specifically enforced, then I highlighted, it may be rescinded and delivered up to be cancelled, and the court, if it refuses to enforce the contract specifically, may direct it to be rescinded and delivered up accordingly. Is it clear?
Yes,
Anyone can unmute and read the 52nd question.
52nd question. Is there any time limit, comma, if any person is dispossessed without his consent of immovable property otherwise than in due course of law, comma, for filing a suit, comma, to recover possession thereof? Which one is correct option? Question mark. Option A. No suit under Section 6 of the Specific Relief Act 1963 shall be brought after the expiry of 6 months from the date of disposition or against the government. Option B. No time limit is prescribed. Option C. Within a reasonable time limit, suit may be filed. Option D. It depends upon the nature of the case. Option A. Answer.
Option A is the answer. Okay, now you need not to write the read the comma. You need not to read the full stop. You need not to read the colon. But when there is a quotation is there, yes, you can read it. I quote, then I unquote at the end when the quotation ends. But you need not to read even a question mark also when you are reading, except quotation. Is it clear?
Yes, sir.
Of course, you can write a slash also, but Professor Hussain, students will not say slash, they will not say stroke, they will not say oblique. What do they say?
Amb.
That is and, ampersand is and. Virgule. Virgule. Virgule, virgule means slash, oblique, or stroke. Okay. Now let us come to the next point here. Now the 53 question, maybe 53rd question. In determining the amount of any compensation awarded under the section 21 of the Act shall be guided by the principle specified in the section. A. 73 Indian Contract Act 1872. B. 74 Indian Contract Act 1872. C. Section 19 specifically for Act 1963. D. Section 20 specifically for Act 1963. Which one is the appropriate answer?
Option A.
Option A. Option A.
Option A is the appropriate answer. If the 73 Indian Contract Act will be applicable over there regarding the compensation is concerned. Yes, 54th question. How the recovery of the specific immovable property may be enforced? Which one is the correct option? A. A person entitled to the possession of the specific immovable property may recover it in the manner provided by the specific Act. B. A person entitled to the possession of specific immovable property may recover it in the manner provided by the Transfer of Property Act. C. A person entitled to the possession of the specific immovable property may recover it in the manner provided by the law of contract. D. A person entitled to the possession of the specific immovable property may recover it in the manner provided by the Code of Civil Procedure.
Option D.
Option D. Option D.
Option D is the right answer. Now 53 question, 55 question. Anyone can unmute and read?
Sir, could you please scroll down?
Yeah, it is there. Already is there.
Section 55. Sorry, question 55. The court may properly exercise discretion to decree specific performance in any case where the plaintiff has done substantial acts or suffered losses in consequence of a contract capable of specific performance provided under which clause of section 20. Option A, class 1. Option B, class 2. Option C, class 3. Option D, class 4.
Option D, class 4.
WRONG.
Option A, sir.
WRONG.
Option C, class 3.
Sir, option B.
Option C, class 3. Can I say, is it a class 3 or subsection 3?
Subsection 3, sir.
If you specifically see it, let me check what exactly the wording of section 20.
No clauses, sir. Only subsections in
Yeah,
section.
let me check it because we cannot supposed to say in that one. Section. What is the distinction between the Specific Relief Act? Discretion as to the discretion specific performance. That means the tail is there. When the tail is there, we don't say subsection, we'll say class. Is it clear? When the tail is here, means heading is here, then 1, 2, 3 comes, we don't say it's a subsection, it's a class 1, class 2. This is subclass A, subclass B. Is it clear?
2018 amendment, sir.
2018 amendment. Okay, now let us see that. Okay, because without wasting the time regarding that one. Okay, if it is not class, okay, just section. Agreed? Agreed?
Yes, sir.
Okay, later we will see it. 56th question. Discretion as to the decreeing specific performance provided under the section. A, 10. B, option B, 14. Option C, 20. Option D, 41.
Option C.
Option E.
Option C is the right answer. It is a 20th the discretion as to the decreeing the specific performance is. 57th question. The following kinds of remedies may be granted by a court under the provision of the Specific Relief Act 1963. Find out the odd man out. A. Recovery of the possession of property. B. Specific performance of the contract. C. Rectification of contract. And D. Rescission of contract.
Option A, recovery of possession of property.
WRONG.
Option B,
Option C,
specific
sir.
performance
Option
of
C.
contract.
If you say option B, specific performance of a contract, WRONG.
Option C, rectification of contracts, sir.
Why?
Instrument.
It is a
Rectification of
rectification of instrument, not contract. Is it clear?
Yes, sir.
Okay. Now 58th question. The following kinds of remedies may be granted by a court under the provision of the Special Relief Act 1963. Find which one is false one. A. Cancellation of contract. B. Cancellation of instrument. C. Declaratory decree. D. Injunctions.
Option A.
Cancellation of contract.
Because you know the equation which I made earlier, and here I made it, and hence we can say it is a cancellation of instrument. It is not a cancellation of contract. Is it clear?
Yes, sir.
So now you know the technique of fishing. What do you say fishing in another language? I mean, in a good terminology. Angling, A-N-G-L-I-N-G, angling. Okay, 59th question. Honorable Supreme Court and various high courts have categorically held that Specific Relief Act 1963 is a dash which merely stipulates the rules of pleadings and the procedures to be followed by the court before granting the specific relief. Option A, substantive enactment. Option B, adjective enactment. Option C, procedural enactment. Option D, civil enactment.
Option C,
Option A.
procedural.
Option A, sir.
Option C, procedural.
If you say option A, WRONG.
Option C, procedural enactment.
If you say option C, procedural enactment, RIGST, right. It is a procedural enactment, not substantive enactment, not adjective enactment, not civil enactment. Is it clear?
Yes, sir.
60th question. Injunctions serve as a similar purpose as a specific performance. The difference is that with a specific performance, the court orders a party dash. With an injunction, the court often orders a party dash. There are two dashes are there. A, not to do something and to do something. Second gap, blank. B, to do something and not to do something. C, refraining from doing something and to do something. Option D, to do something and refraining to do something. Which one is the appropriate couple?
Option D, sir.
Option C, sir.
Option D, do something.
If you say option A, WRONG.
Option D, sir.
If you say option D, WRONG.
Option C, sir. C.
If you say option C, WRONG.
Option B.
It is coined by my own intelligentsia to make it confused. The exact wording used is there to do something in specific performance. In injunction, not to
Refraining
do,
from doing something.
not to do something. That is their injunction. Is it clear?
Yes, sir.
Which option is right option here?
Option B.
Option B.
Option B, to do something and not to do something is the right answer. 61 question. Anyone can unmute and read?
What is specific relief? It is a dash remedy. It aims fulfillment of an obligation and obtaining of the thing for which a person is entitled under a and of which he has been deprived. In other words, it is a compliance of a contract specifically, which has been refused to comply with. Option A, negative and contract. Option B, positive and contract. Option C, positive and agreement. Option D, civil and contract.
Option D, sir.
Option D, civil and
If you
contract.
say D, civil and contract, it is wrong.
Option C,
Option
positive and
If you
agreement.
say option C, positive and agreement, it is wrong.
Option B, positive and contract.
If you say option B, positive and contract, RIGHT, right. See, all are very near, but there is a difference. So right option for the 61 question is, it is a positive remedy, and the next option is dash is agreement. Okay, I did not put the dash for that agreement, is it not? Yeah. Anyway, the 62 question, meaning of a specific performance law falls into three categories. Which one is not related to it? Number one, those which defines rights. Option B, those which defines substance. Option C, those which defines remedies. Option D, those which defines procedure.
Option B.
A.
Option
If
B.
you say option A, WRONG.
Option B.
If you say option C, WRONG. If you say option D, WRANG.
Option B.
Which is not related to.
Yes, sir. Option B.
Option B, those which define substance, there is no such a thing. But A is there, those which defines right is there. C, those which defines remedies are there. D, those which defines procedures are there. So I concocted, I fabricated those which define substance. Yes, 63rd question. He was not entitled to the specific performance of his contract, as that would require supervision by the court of editing the article. Through he would be entitled to damages for lost opportunity of enhancing his reputation was observed in the case of A. Forrar versus National Magazine Company Limited. B. Cannon versus National Magazine Company Limited. C. Collier versus National Magazine Company Limited. D. Joseph versus National Magazine Company Limited.
Option D, Joseph versus National Magazine Co. Limited.
Suppose if I say RIGHT, Lavanya, can you tell me how did you make it out?
I have seen somewhere, sir.
Okay, that means your sixth sense worked over there. Okay, now you tell me, supplementary question. What is wrong in this? Check it. I am speaking about the punctuation marks. I committed a mistake voluntarily. I want to find it out. What is the mistake I committed?
After co, there is a dot and comma.
No, not comma. Continuation is there. Ending is there. That otherwise, yes, it is only the
Co-dot.
co-dot. Now you tell me.
Company should be dot. Co-dot.
Yes, now you tell me. In abbreviations, in which place it falls among the four? I gave you number one, initialism, number two, acronym, number three, shortening, number four, contraction. Among the four type of the abbreviation, capital C small o stands where?
Shortening, sir.
It is a shortening. I don't know why you are taking that much time. I gave the example February. F capital letter, E small letter, B small letter, then full stop. Its full form is February. February. It's a shortening. So this is the style you have to write it. Whenever you write the case law, either in the body of the case law or in the footnote of the case law, or you write in the bibliography, or you write in the reference. Always
Jai Hind.